Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. The court recently released a document that was temporarily under seal in Idaho versus Kohberger. It was an item filed February 24th, 2025, the date that Judge Hippler set as a deadline for both parties' motions in limine, and this particular filing is a motion in limine. It is the state's motion in limine. It is entitled Redacted State's Motion in Limine regarding text messages and testimony. This is perhaps the most compelling evidence that has been withheld from the public since the horrendous events that happened at 1122 King Road back on November 13th, 2022. These texts were placed on November 13th, 2022. Page 1 of the state's motion in limine regarding text messages and testimony states, comes now the state of Idaho by and through the Latah County prosecuting attorney and respectfully moves the court for an order in limine allowing the state to admit the text messages of, and the name is redacted, it's stated here as D as in David, M as in Mary, DM, on November 13th, 2022, and the testimony from DM and BF regarding their conversations with each other on November 13th, 2022. 2 points here. First, BF is the initials for one of the two surviving roommates of the tragedies at 1122 King Road. The second is DM. The other matter that I want to call to your attention is that as we look at the substance of these texts, BF also, according to the state, texted DM. But there's a little bit of a difference here. It says here that the state is moving the court for an order in limine allowing the state to admit the text messages of DM, but not the text messages of BF on November 13th, 2022, and the testimony from both DM and BF. So that's a little bit of a difference here regarding how the evidence is being treated. I'm not sure why. It then goes on to say the phone records were discovered on the hard drive of DM, iPhone extraction, provided on April 5th, 2023, and the state's Exhibit 18 from the grand jury record C, states Exhibit S as in Sam 1. Going on to page 2. The testimony of DM and BF was provided to the defense as part of the grand jury record. States Exhibit S as in Sam 2 and States Exhibit S as in Sam 3 attached. So what this appears to suggest is that DM and BF provided testimony at the grand jury proceeding in May of 2023 that led to the indictment with the 5 first-degree felonies that Mr. Kohberger has been charged with. And if we recall back at just before the time of the grand jury proceedings, the state was endeavoring to speak with BF, to call her as a witness to what was then supposed to be a preliminary hearing that was to occur in late June 2023, and it was canceled because of this very grand jury indictment. Another point I want to bring to your attention is the fact that this is a motion in limine. It doesn't mean that Judge Hippler is going to grant this relief to the state. The defense has a due process privilege of providing a response, possibly in opposition, to the state's moving in limine regarding these text messages and testimony, to have them admitted as an exception to hearsay, which is what they're looking to do. If you look at page 2 of this motion, hearsay is an out of court statement that is made to prove the truth of the matter asserted. But what the state of Idaho is doing is saying that there are certain exceptions to the hearsay rule. If you look at page 2, such as Idaho Rule of Evidence 8031, present sense impression. This is a statement describing or explaining an event or condition made while or immediately after the declarant perceived it. And 803.2, excited utterance, a statement relating to a startling event or condition made while the declarant was under the stress of excitement that it caused. And then the state of Idaho goes into substantial amounts of case law, both at the federal level, because this is dealing with federal law in certain instances, and the state, certain cases here, law. And you can look at the citations that go into pages 2 and 3. Then we go to page number 4. This is where these texts are, and I'd like to read this to you. The argument. D as in David, M. DM's phone records contained in Exhibit S as in Sam for November, contained in Exhibit S as in Sam 1 for November 13th, 2022, and BF's testimony contained in Exhibit S as in Sam 2 as to what DM told her should be allowed at trial. In the case at bar, starting on November 13th, 2022 at 2:10.29, this appears to be 2 o'clock in the morning, 10 minutes, 29 seconds, DM sends a text message to E.G., Uber driver, to inquire if he is driving. The state submits this text message exchange as not hearsay because it will be offered for the truth of the matter asserted, i.e., E.G.'s driving status. Instead, it would be offered to show a timeline for the night, i.e., that DM was awake and texting at 2:10:29. Now, with respect to E.G., we do not know if this is the same driver who brought Maddie and Kaylee home from the grub truck just before 2 a.m. on the 13th of November, 2022. Next, it states DM was awake and texting at 2:10:29. But then there's a big hole here from 2:10:29 through 4:19:07. It states next that from 4:19:07 to 4:21:50, DM attempts to call BF. Xana Kernodle, Kaylee Gonzalez, and Madison Mogan, all calls went unanswered. The records of these calls are not hearsay as they do not meet the definition of a statement, quote, oral assertion, written assertion, or nonverbal conduct intended as an assertion under IRE 801A. And then comes the texts from 4:22:08 to 4:24:27 between allegedly DM and BF. Now, again, ladies and gentlemen, I must assert my question again as to why nothing from 2:10:29 through 4:22:08, these crucial moments in time, because the crimes were alleged to have occurred starting at 4 o'clock a.m. This is what the state of Idaho has persistently stated, beginning in the affidavit of probable cause that was signed under penalty of perjury by Detective Brett Payne on the 29th of December 2022. It is unclear if DM did not use her phone at all during these minutes and hours, or if she did use the phone and for some reason the information's being withheld. In any event, it states here, from 4/22/08 to 4/24/27, DM and BF send the following text messages. DM to BF, no one is answering. DM to BF, I'm RLLY confused, RN. DN to BF, I'm RILLY or I'm RLLY confused, M. DM to Gonzalez, Kaylee. DM to Gonzalez, what's going on? BF to DM, yeah dude, WTF. BF to DM, Xana was wearing all black. This statement right here, Xana was wearing all black, seems to come out of nowhere. Why would BF to DM say Xana was wearing all black if perhaps there wasn't some prior conversation between the two that was going on between 4 o'clock a.m. and 4/22/08? In any event, it continues. BF to DM, Xana was wearing all black. DM to BF, I'm freaking out, RN. DM to BF, no, it's like ski mask almost. This again is a comment that seems to appear out of nowhere. There's no context for this. No, it's like ski mask almost. It appears that there had to have been some prior texts that, for whatever reason, are not being included here, because this appears to relate to the man clad in black who wore a mask that the state of Idaho has been informing the public about since the time of the affidavit of probable cause. BF to DM, Xana was wearing all black. DM to BF, I'm freaking out, RN. DM to BF, no, it's like ski mask almost. BF to DM, STFU. BF to DM, actually. DM to BF, like he almost had SOEMTBINF over, is for head and little ND mouth. DM to BF, BF, I'm not kidding. Oh, am so freaked out. BF to DM, so am I. DM to BF, my phone is going to die, FUCK. BF to DM, come to my room. BF to DM, run. BF to DM, down here. Going on to page 5, it states, all of the above declarations are present sense impressions and excited utterances. This is supported by DM's grand jury testimony, where she indicates she just witnessed a startling event, i.e., heard noises in residence and saw an unknown male in the residence. So here we have confirmation from the state that DM, in fact, provided testimony at the state grand jury proceedings. It goes on. The declarations indicate both BF and DM are trying to make sense of the startling event contemporaneously, immediately following the startling event, in parentheses, i.e., no time for reflection or fabrication. See DM's grand jury testimony attached at Exhibit S as in Sam 3. Then it continues at 4/24/39. DM calls Ethan Chapin. Call unanswered. This phone record, like the other records of calls, is not a statement pursuant to IRE 801A. DM and BF continue to text. At 4/24/58, DM texts BF, quote, I'm SCRWDTHO, end quote, and BF responds. At 4/25/16, quote, yeah, IK, in capitals, but it's better than being alone, end quote. Again, both statements are admissible as present sense impressions and excited utterances, as they are describing an event or their state of mind and are spontaneous reactions to the event rather than the result of reflective thought. At 4:27 DM calls Gonzalez, call unanswered. And 42844 DM calls Kernodle, call unanswered. These are not statements pursuant to IRE 801A. At 4:32:57, DM sends a text message to Gonzalez stating, "Please answer." This statement is present sense impression showing DM's perception of events and an excited utterance, spontaneous reaction to the event rather than the result of reflective thought. Now, why we keep hearing that, the result of reflective thought, is that the general rule is that something that is made as a result of, when someone is under panic, under stress, an excited utterance, it tends to be something that can be relied on because there's not a lot of time for quote-unquote reflective thought. The next morning, DM sends the following text messages starting at 10:23:23. So I just wanted to point out that between the hours of 4:32:57 and 10:23:23, there is no explanation if DM stopped texting, stopped calling. It just basically, it cuts off at this 4:32:57 point and continues on at 10:23:23. DM to Gonzalez, please answer. DM to Mogan, are you up? DM to Gonzalez, are you up? These text messages are not hearsay according to the state because they will not be introduced for the truth of the matter asserted. Even if deemed hearsay, that's a statement outside of court, proffered for the truth of the matter asserted, ladies and gentlemen. They are allowable as present sense impression, or they reflect a consistency and continuation of DM's text messages from the night prior and reflect her then perception of what was occurring, i.e. waking up and realizing that she had not heard from her roommates. At 11:39:09, DM has a text exchange with her father, BM. These statements are not hearsay, as they will not be introduced for the truth of the matter asserted, but instead show a timeline for the morning. At 11:50:55, DM receives a text message from J stating, "Bro, this text message will not be introduced for the truth of the matter asserted." At 11:50:58, DM calls EA. This phone record is not a statement pursuant to IRE 801A. DM receives a text message from J at 11:51:01 and a vandal alert at 1:04:01. These texts are not hearsay because they will not be introduced for the truth of the matter asserted, but instead to show a timeline of events. So one point here, we don't know who EA is and we don't know who J is. This document continues with further legal argument why relief should be granted. There's a conclusion. This is signed by Ashley Jennings. She is the senior deputy prosecuting attorney for Latah County. It's dated the 24th of February. And because this is a motion in limine, we await to see the defense's reply, if any. We await to see the defense's response, if any, in opposition to this matter. And we await the reply from the state to the defense's response, if any, before the matter will be called up for hearing by Judge Hippler on the 9th and possibly going into the 10th of April. That's when the hearings on the motions in limine are scheduled for. So nothing will be decided on this matter either way until after oral argument, and then we can expect an order from Judge Hippler thereafter. This will now conclude this episode of the Indie Zone podcast. This is Kathy. Thanks for joining us here today.